Tantor Audio, a division of Recorded Books, presents Crook County, Racism and Injustice in America's Largest Criminal Court, by Nicole Gonzalez Van Cleve. Narrated by Nicole Gonzalez Van Cleve. To my loving sons, Dylan Salvatore Van Cleve and Micah Gonzalez Van Cleve, may you someday dust off this book, read it, and learn how justice used to be. Thus grew up a double system of justice, which erred on the white side by undue leniency and the practical immunity of red-handed criminals, and erred on the black side by undue severity, injustice, and lack of discrimination. It was not then a question of crime, but rather one of color, that settled a man's conviction on almost any charge. Thus Negroes came to look upon the courts as instruments of injustice and oppression, and upon those convicted in them as martyrs and victims. W.E.B. Du Bois, The Souls of Black Folk. Preface. The U.S. Supreme Court ruled that justice must satisfy the appearance of justice. We expect our criminal courts to be legitimate, fair, and race-neutral. Most legal scholars, practitioners, and the general public presume that racism exists adjacent to our courts, if at all, in legislation, policing, and incapacitation. In fact, the violent deaths of Eric Gardner, Michael Brown, Tamir Rice, and Laquan McDonald punctuated the harsh reality, which most people of color know too well, that there are two systems of justice in America, one for upper and middle-class whites, and another for the poor and people of color. When many of the officers involved in these cases were not indicted on criminal charges by local prosecutors, and when justice came excruciatingly slow, the public media and policymakers began seeing the courts as part of this double system of justice, justice with a white side and justice with a black side. While these high-profile cases began dispelling the myth of a colorblind criminal justice system, most Americans still do not expect racism to embed itself with impunity in our American criminal courts. How could it, given the myriad due process protections, legal safeguards, and a courtroom record supposedly holding judges and lawyers accountable? This book is the long overdue explanation. Imagine the classic images from the Jim Crow era. Signs over water fountains, doors, and bathrooms. One sign from the Jim Crow Museum is poignant. It reads, "No dogs, no Negroes, no Mexicans." This sign publicly identified and separated black and brown people into separate spaces and punctuated the principle that people of color are at the same level of animals, specifically dogs. Imagine the justice system having a similar sign outside the courthouse doors, where there is a type of backdoor justice that the poor and people of color enter, while whites enter from the front, or perhaps enter just to govern the system from which they are generally exempt. Imagine the cultural persistence of decades of patterned segregation in the criminal justice system, of cultural practices that minimize, marginalize, and abuse the backdoor entrance to criminal justice in America. Eventually, you could take down the signs and let the system run on its own racialized momentum. If there are two criminal justice systems, they are two systems that are separate and unequal. One with a front door and one with a hidden back door, where the majority of citizens, the poor and people of color, experience America's failed promise of fair and equal justice. This is not what I expected to find when I began a study of the criminal courts in Crook County, Chicago, the largest unified court system in America. I found the criminal courts serving as a crucial gateway where racism and discretion collide, with dire effects for both the experience and the appearance of justice. These findings assault our expectation of justice and our notion of racial equality in an era of supposed color blindness. Michelle Alexander's book, The New Jim Crow, Mass Incarceration in the Age of Colorblindness is one of the most recent works that has generated public and scholarly interest in mass incarceration and its dire effects on communities. There, she takes the reader on a critical journey through history, policy, and politics to argue how mass incarceration is the new Jim Crow. While her book is eloquent, accessible, and an important effort to harness all the empirical work of other social scientists, Alexander admittedly paints, with a broad brush, how race and racism explain mass incarceration. She asks the poignant question, how exactly does a formerly colorblind criminal justice system achieve such racially discriminatory results? She provides a pessimistic response by saying that the evidence will never be available in an era of colorblindness. Ironically, she says that one can close the courthouse doors to any claims of bias in a colorblind era. This book is an empirical answer to that paradox. It is an opening of the courthouse doors. I detail how the doing of colorblind racism transforms the gateways of criminal justice, our criminal courts in particular, from central sites of due process to central sites of racialized punishment. I show how extreme racial punishment embeds itself in process, not just in sentencing outcomes or in locations of punishment like prisons, but in due process procedures that appear infallible to legal scholars, policymakers, and the general public. More specifically, this ultimately impacts reform issues that explicitly address the public defense system in America. Pre-trial abuses and procedures are punishing defendants before they are found guilty, while defense attorneys acknowledge a system that does not afford dignity to their clients. Reforming indigent defense must start with a lens that focuses on the entire courtroom workgroup of legal professionals, judges, prosecutors, and defense attorneys who create the quality and experience of justice for the mostly minority and impoverished offenders. A law professor in Chicago discouraged me from examining the culture of the courts, asserting that Steve Bulgara's Courtroom 302 had already told all the stories from the trenches of justice in Crook County, Chicago. The goal here is not to provide a series of stories, but instead to show these stories as part of a sociological account of justice in an era of mass incarceration. In other words, I seek to provide an empirically based, theoretical framework to understand how these stories aggregate to a larger sociological count of how our courts operate and how racism serves as an essential function. This research began 15 years ago as an ethnographic study of the Prosecutor's Office and the Public Defender's Office, where I clerked and participated in their respective cultures. I later returned to this field site and supplemented my ethnography with 104 interviews with judges, prosecutors, and public defenders, and another 1,000 hours of additional observations from 130 court watchers trained in collecting qualitative data in the courthouse. This ambitious court-watching effort took 2 years to complete. It is upon this robust data set that I build an empirical account of racism in our criminal courts. While the book assumes a narrative style, let it not distract from the data and careful analysis required to come to the conclusions in this study. In addition, this work assumes the vantage point of court professionals and provides an account of how they see defendants, victims, families, and other consumers of justice. These stories of defendants, victims, and families are the backdrop of this account, but they are omnipresent. While the defendants themselves could have testified to these abuses, and often have, it is powerful to see these stories unfold through the professionals whose actions define the experience and appearance of justice in our courts. Plenty of ethnographic accounts turn the lens on marginalized populations. My goal is to turn the lens on those in power as they do the marginalizing. My hope is that this work will encourage other ethnographers to do the same. Identify the marginalization and then shift the lens to those who create the conditions. That being said, it is important to note that protecting the anonymity of those described in this book, be they judges, attorneys, or defendants, is imperative. Pseudonyms are used. Courtroom locations and exact dates and years are masked. In some cases, identifiable features of cases, attorneys, and defendants are changed to avoid the risk of revealing the subjects as they are described in this book. However, I will reveal an entire culture of racialized justice that is larger than any individual judge, prosecutor, or defense attorney. As we shall see, this social system of racialized justice has deep roots and certainly many branches. It is with deep reverence and respect that I acknowledge the families, defendants, and victims whose stories are profiled in this research. Some are still serving time in Illinois prisons as a result of the decisions and practices recounted in this book. Some are now free and coping with the consequences of being marked and marginalized by a criminal record. Others have died in prison. While their identities remain anonymous, their collective story is no longer invisible. I remember and saw your story, and now others will as well. Introduction. Opening the courthouse doors. The Gang Crimes Unit of the State's Attorney's Office in Crook County, Chicago, was where the most bullish state's attorneys worked. Many were nicknamed for their ferocity, sounding like their own gang of sorts. Dirty Dog Richardson, Beast Man Miller, William Billy Club McManus, to name a few. These were the types of men who comfortably put both feet up on their desk and welcomed you to their office with the soles of their shoes. Nameless mugshots of a stream of Black and Latino defendants acted as wallpaper for their office, a visual souvenir of convictions and conquests. This wallpaper provided a striking racialized backdrop to the practice of criminal law and was my introduction to the criminal courts and criminal justice. Nearly all the prosecutors who built and exhibited this showpiece were white. In contrast, nearly every mugshot in the mural was a person of color. I moved backward several steps so I could see the entire wall, and then I paced reverently along it, as though I were scanning a memorial of the dead. I was the only person of color in the room. I was the prosecutor's unlikely new law clerk, a person who looked more like someone from the mural than an aspiring attorney in the office. Truth be told, I felt like a little girl playing dress-up in a power suit. I tried to keep my head down and fit in, but I was visibly stunned at the scale of the mural and the undeniable color line of colorblind criminal justice. Sensing my awe, my supervising prosecutor narrated the environment. You see the scum that we deal with? The mural provided a vivid, symbolic picture of who the other was in this dynamic. Court professionals, prosecutors, defense attorneys, and judges alike often use the phrase working in the trenches to distinguish their work in the criminal justice system as separate and different from the more cushy or elite aspects of law. The trenches implies a warlike dynamic, a place to hide under hostile fire, and begs the question, who is the enemy? I scrawled this note and many others in a small corner of my legal pad that became my first ethnographic field observations at this site. Nameless mugshots of a stream of Black and Latino defendants provided a collective racial caricature of the prosecutor's central mission as court professionals. In the words of this prosecutor, they were taking this kind of scum off the street. This book exposes the myth of colorblind criminal courts and examines how racial meanings become ingrained within the administration of justice despite procedural protections. Incarceration in the United States has grown 7 times over the past 40 years. This growth is concentrated among Blacks and Latinos and has transformed our social and political landscape, including the racial composition of our courts and prisons. The black and white difference in incarceration rates is particularly astounding. By all other social indicators of inequality, incarceration is unmatched. Racial disparities in unemployment, 2-to-1, non-marital childbearing, 3-to-1, infant mortality, 2-to-1, wealth, 1-to-5, are all significantly lower than the 8-to-1 black-white ratio in incarceration rates. Furthermore, racially disproportionate incarceration contributes to a cycle of poverty, growing structural inequality, and higher rather than lower crime rates. Numerous works examine the collateral consequences of mass incarceration on poverty, crime, and inequality within communities of color and even on daily life. Yet few works discuss the impact of racial disparity on criminal justice apparatuses themselves. In fact, had I not ventured into the courthouse as a budding ethnographer assuming the role of a law clerk, I would not have seen the striking parade of black and brown defendants through courts managed by mostly white attorneys and judges. This book represents my journey to understand how the racial and social divides that manifest in the era of mass imprisonment affect the experience of justice in our criminal courts and the due process procedures that appear to be race-blind. Inheriting racism. Criminal courts are transformed by patterns of segregation created by mass imprisonment. As such, the lawyers processing defendants tend to be white, educated, and upper middle class, and those being processed tend to be minority, uneducated, and poor. In the supposedly post-racial era of Obama, America's purportedly colorblind racial ideology and racism manifest in more covert, institutional, and structural ways. For attorneys working in the criminal courts defined by racial segregation between defendants and decision-makers, such obvious racial inequality in spaces intended to be race-neutral creates a cultural dissonance among professionals who inherit this heightened racialized social system. This book shows how professionals reconcile the cultural dissonance of racial segregation with the moral and institutional imperative to process cases and people en masse in the criminal justice system. It is about how criminal justice professionals in the main gateways of mass incarceration participate in the incarceration machine despite obvious racial divides, uncertainty with the meaning and morality of what they do, and a conflict about what real justice means in a punitive era of being tough on crime. I explore how attorneys cope within the courts and how the racial divides between defendants and decision-makers transform our courts into central sites of punishment, the likes of which legal scholars and reformers have failed to anticipate and interrogate. This book raises questions about modern forms of colorblind racism and the claim that they are kinder, gentler, and different from the overt forms in the past. As I show, imbued with the institutional authority of the state, hidden in the organizational contours of due process procedures, and normalized into insular cultures, colorblind racism transforms into state-sanctioned racial violence. It took years of revisits to this field site by myself and with other researchers to understand how the enigmatic features of colorblind racism were not only operative, but central to the efficiency of the system. The segregated structural divides created by mass incarceration inform a type of racialized legal habitus, of ideologies and practices internalized in the production ethic of the court procedure, the cultural engine of an entire assembly line of criminal justice. This habitus is like a feedback loop created by the broader trends of mass incarceration, the punitive turn in penology and punishment, and the intensification of surveillance and policing that impacts the lives of the poor and people of color. Consequently, these trends in mass incarceration and the lingering cultural and racial stigmas they reproduce become incorporated as embodied history, internalized as second nature, and so forgotten as history. It is as though attorneys inherit a culture of racism that existed a priori, before their participation. The a priori racism that defines the court culture and the legal habitus existed long before they arrived at the courthouse, and it will sustain itself long after they retire. From an institutional standpoint, the cultural beliefs and practices of this habitus drive all the taken-for-granted assumptions that define discretion in the criminal courts. These discretionary actions are the gaps between the formal rule of law and how attorneys interpret these rules and practice. From how one comports oneself in the courtroom as an insider to the very norms of practice that define the legal community, this embodied history aids in the categorization of cases and people that professionals manage as case flow. This habitus shapes the sharp moral boundaries between the mostly white professionals who process cases and the minority offenders who are being processed. Traditionally, one thinks of colorblind racism as an enigmatic type of racism that codes racial difference as moral difference, thereby obscuring racial divides and the social inequalities they produce. Coded racial language makes the expression of colorblind racism a slippery, apparently contradictory, rhetorical maze, with whites concealing racial beliefs with rhetorical moves and verbal strategies. Haney Lopez extends this concept with the term dog whistle politics, or the political use of coded racial appeals that manipulate hostility towards non-whites. As he argues, the resonance of these racialized appeals push the political tides towards policies that reproduce white elite advantage and amplify social inequality among middle-class whites and non-whites. Studying the criminal courts brings these theories into the realm of everyday practices, where white advantage and racial violence are reproduced in our most sacrosanct legal institutions. Scholars of race contend that racism is more than simply ideology. It is part of an entire system of institutions and structures that organize society. However, in research, the doing of colorblind racism is observed as a linguistic sleight of hand, seen and heard only through its verbal expression and linguistic maneuvers, or in the macro-level political realm. As Eduardo Bonilla Silva argues, these racial practices operate in a more subtle, now you see it, now you don't manner. Yet, as Ian Haney Lopez shows, the effects on inequality and politics are dire. Accounts of structural racism acknowledge that racial inequality is rarely produced by acts of blatant, identifiable racism. It is systemic, institutionalized, and frequently functions without the active participation of any one bigoted decision-maker. Yet critical race scholars note such theories depersonalize how racial prejudice, racial inequality, and racial power are experienced between people or within institutions. Missing is an empirical account that advances colorblind racism as more than just a doing of rhetoric, but a type of complicated habitus that informs institutional exchanges. Racism is not just done out there in traditional measures of inequality like education, income, job prospects, and the creation of racial stigma, but also in the everyday workings in here, in the interaction and social exchanges that define the experience of institutions. Examining the criminal courts and the procedural exchanges required to process what has become a racialized underclass of marginalized offenders reveals how colorblind racism is practiced within institutional boundaries, even aiding in the efficiency of the system itself. Criminal courts and the doing of racism. In criminal courts, lawyers, especially prosecutors and judges, are forced to deliberate on the morality and criminality of others on behalf of the state. As such, morality is a central currency wielded by professionals. By the nature of being held accountable in the courts, the defendant is labeled as immoral to the point of criminal. The professionals who process defendants, especially prosecutors who are at the helm of these legal proceedings, draw sharp distinctions between themselves and the defendants they process. These labels are dichotomous and absolute, and they rigidly delineate the prosecutor from the prosecuted, the judge from the judged, the defender from the defended, all distinctions that sharply demarcate the moral from the immoral. Similar to moral boundaries maintained in the criminal courtrooms, morality is a currency wielded in the doing of modern racism and is instrumental in drawing boundaries between whites and blacks while feigning colorblind ideology. As the logic goes, disdain for people of color is based not upon racial difference or inferiority as a set of biological features, but upon moral inferiority that minorities embody. Often these immoral labels reference historical stigmas, stereotypes, and controlling images associated with blackness and brownness, the supposed tendency to be lazy, hypersexual, and undermotivated, for example. These distinctions about morality and criminality on the one hand, and morality and racism on the other, meld within the context of our criminal courts. There, one's moral status is conferred by both legal categories and racial categories. As such, the immorality of defendants is both a criminal distinction and a racial one. In this logic, disdain for defendants is not based on the color of their skin, but on the moral violations they embody. With the authority of the law, a host of racialized abuses are not only allowable in public spaces, but are seen as deserved and justified. Because a moral rubric supersedes racial differences, professionals maintain the court process as race-neutral or colorblind. A constant threat of violence patrols these courthouse arrangements. Armed sheriff's officers police boundaries in the courtroom, boundaries that separate minorities from the court proceedings, and periodically inflict random and cruel abuses on courthouse visitors as an example of how to stay in line. There is little outside accountability from the public or from other areas of the legal profession. The professionals practicing in the criminal courts operate in an environment where abuse, threats to the defendants and their families, and the policing of racialized arrangements is normalized as part of a community culture that informally governs the courts and allows professionals to valorize the moral purpose of their work. Without accountability and oversight, the criminal courts are their own social system, governed violently, with race underscoring a grotesque caricature of due process and the rule of law. A journey into the trenches of justice. When I began this research on the criminal courts in 1997, I never intended to write a study on punishment and race. I anticipated examining traditional concerns of jurisprudence, perhaps a revisiting of Malcolm Feely's classic work, The Processes of Punishment, in which he looked at the pretrial costs of punishment imposed upon offenders before they plead guilty. I suppose it is a sad irony that my hypothesis was partially correct. I found racial punishment before, during, and after conviction. This style of punishment was not inflicted just on defendants. It was inflicted on their families or anyone, even victims with black or brown complexions who happened to walk into the courthouse. When I began writing my first field notes in the courts, I was only a 19-year-old undergraduate student. I was granted leave from traditional classes, and my field site was a training ground for the ethnographic study of the culture. I chose the Crook County, Chicago courts as my field site because I had ambitions of going to law school and eventually becoming a prosecutor. I assumed a participatory role at the site, working as the prosecutor's law clerk. Like many Americans, I anticipated a law and order arrangement. Tough on crime rhetoric dominated my perceptions of our courts. Yet those first days on the job as both a clerk and a young ethnographer, I found my senses assaulted by the number of Black and Latinos on the list of detainees in the lockup. One by one, they paraded in orange jumpsuits, numbers written on their arms, some in shackles, their hair unkempt and unclean from the Cook County jail, many of them younger than I.
Sample complete. Ready to continue?